5, 4, 3, 2, 1, start. Criminal Appeal number 28/2000, page 3 of 12, informed that she has died during the process of abortion and the dead body was lying at the table in the clinic, full stop. On the statement of PW6, made an endorsement exhibit PW10 over A and sent the Rukka through PW7, full stop. On the basis of this information, the above mentioned FIR was registered, full stop. A lady constable PW1 was called telephonically and a photographer PW4 was summoned to take the photographs of the scene, full stop. The dead body and the bucket containing blood and pieces of flesh were sent to the mortuary, full stop. After completion of investigation, charge sheet was filed against the appellant, full stop. After recording the prosecution evidence and the statement of the appellant under section 313 CRPC, the impugned judgment convicting the sentencing the appellant as already mentioned was passed, full stop. Stenja, learned counsel for the appellant, challenging the conviction, urged that the appellant was not qualified to perform abortion and she had asked PW6 to take his wife, that is, the deceased, away to a hospital as her condition was serious, full stop. However, as he did not take her, she died in her clinic, full stop. The investigating officer has not seized any surgical equipment, nor there was any other equipment available at the spot to show that the appellant conducted the surgery resulting in the death of the deceased, full stop. Allegedly, rupees 500 were given to the appellant by PW6, and as per the prosecution case, the appellant had not gone out anywhere, but after her arrest on her personal search only rupees 300 were recovered, which falsify the version of PW6, full stop. The appellant never portrayed that she was a qualified doctor who performed surgeries, and on the board outside her clinic her degree was shown as an Ayurvedic doctor, full stop. Stenja. The investigating officer has not seized any clothes of the appellant or apron which was blood stained, thus showing the appellant had conducted this abortion, full stop. There are material contradictions in the statement of PW6 and PW10, full stop. It is pointed out that PW6 in his testimony has stated that he was taken to the police station along with the dead body where his statement was recorded, full stop. Whereas PW10 has deposed that he met PW6 at the spot and his statement was recorded at the spot itself, full stop. Even PW7 stated that all proceedings were conducted at the police station, which fact is contradicted by PW10, who has stated that all the inquest papers were prepared and proceedings were conducted at the spot, full stop. Learned counsel has further contended that no seizure memo was prepared of the bucket which had been recovered from the spot, nor was the blood on the floor as alleged lifted, full stop. Even the arrest memo of the appellant was not prepared, full stop. Since the link evidence is missing, there is nothing to connect the appellant with the flesh found in the bucket or the blood, full stop. The appellant cannot be convicted of the offence, full stop. Therefore, the impugned judgment is perverse, illegal, and contrary to the facts on record, full stop. Stenja. The learned trial court comes to the conclusion that though there is no direct evidence, however, 4 circumstances have been proved against the appellant and thus holds her guilty, full stop. It is contended that from the evidence adduced, except the first circumstance that the appellant was running a clinic in Rohini, rest 3 circumstances, that is, deceased was carrying 6 months pregnancy and was brought by her husband to the clinic of the accused for an abortion, the appellant took the deceased inside the clinic for performing the operation where she died, and her dead body was recovered from inside the clinic, and the medical evidence recording the case of death cause of death have not been proved by the prosecution, and thus the appellant is liable to be acquitted of the charge framed full stop. In the alternate, it is prayed that the incident of the year 1996, the appellant has already undergone a sentence of 5 months and 10 days full stop. Thus, she be released either for a sentence for the period already undergone or on probation full stop. Senja Learned APP for the state contends that there is sufficient material on record adduced by the prosecution to prove the guilty of the appellant full stop. PW6 has deposed about the 6 months pregnancy of his wife and the fact that he had brought her for abortion to the clinic of the appellant, where it was represented that the appellant was competent to perform the abortion and charged rupees 500 for the same full stop. The wife of PW6 died inside the clinic, and when the appellant asked PW6 to take away the dead body of his wife, somebody from the street rang up the police, which reached at the spot full stop. The fact that the appellant was not a qualified doctor and thus not qualified to perform an abortion has been admitted by her full stop. Learned APP states that the factum of performance of an abortion stands proved from the postmortem report exhibit PW9 over A, which opines that the flesh brought by the police in a bucket was the material of conception, and it is immaterial whether the flesh material was of 2 months or 6 months conception full stop. Minor contradictions sought to be brought in the testimony of the witnesses in regard to the proceedings conducted at the spot or at the police station do not go to the root of the matter full stop. Furthermore, PW9 has clearly opined the cause of death to be injury caused during an attempt to evacuate the contents of gestation full stop. Hence, the appeal is liable to be dismissed being devoid of merit full stop. I have heard learned counsel for the parties and perused the records. PW6, the complainant oblique husband of the deceased, has deposed about the factum of taking his wife with 6 months pregnancy to the clinic of the appellant, where the appellant stated that she could safely abort the child as she has been doing it earlier also, for which she would charge rupees 500 full stop. He has further deposed that his wife was taken inside the clinic in operation room at about 2 p.m. and at about 4 p.m. he inquired about his wife when he was told by the appellant that she died during the process of abortion full stop. He went inside the clinic and saw the dead body of his wife full stop. The appellant asked him to take away the body from there full stop. Stanza. At that time, somebody from the street informed the police and the police came at the spot full stop. This version of PW6 is corroborated by the photographs exhibit PW9 to PW12 full stop. Moreover, the defense taken by the appellant is that she had informed PW6 that she was not doing abortions, and then he requested that she may check up the lady otherwise, and her husband left saying that he will come after 1 hour full stop. She checked and found that her condition was serious and suggested that she should be taken to a competent doctor full stop. The appellant waited for her husband for more than 2 hours, but he did not turn up, and in the meantime that lady expired full stop. Thus, the defense of the appellant is that it was not an attempt to abortion, but because the condition of the deceased was serious, she died full stop.